Garima is also there. Yeah.
Oh, good afternoon, Professor.
Yeah, good afternoon. Good afternoon, Beulah.
Good to see you and to hear you after a long time.
Yeah, Professor Heru, how are you?
Yeah, good. How are you, Professor Vajpayee?
Yes. What a pleasure to see you today.
Yes,
Thank you so much
I also glad to see you, Professor Beulah.
Yeah, thank you so much for.
Good to see you. Professor Vajpayee, Professor Heru.
Yeah, how are you, Prof?
Yeah, Beulah, how are you?
Good, good.
Nice, very nice to have you.
Thank you
Hello,
for the platform.
Yes, it's a pleasure to have you. Hello, good morning, Dr. Garima ji. How are you?
Very good morning, Professor Vajpayee.
Yes, nice to see you. Wonderful. Thank you for
Thank you so much
joining.
for your invite.
And Dr. Hanif, thank you so much. I can't thank you enough for your time, actually. Wonderful to see you.
Good morning, Dr. Vajpayee. It's very good to see you and all others here. I'm looking forward to the conference. It's a great opportunity to share the views of everyone.
I know, it's wonderful. Oh, Neeraj, how are you?
They're all good, sir. Hello, sir.
Nice to see you.
We are meeting virtually these days, sir.
Yes, but we have to move on. Let us see.
Yes, sir.
Oh, sir, Professor Shokalingam Saab, how are you, sir?
I'm very fine. I'm very happy to see you.
You are attending some session. That's
Yeah, some sessions. Yeah.
Great. That's great. I mean, but sir, I'm happy that a lot of people have responded so favorably to this event, and they have contributed so well.
Absolutely. Yeah.
So the quality of session in most cases was so amazing and so
Very good.
enriching.
Yeah.
So team, what are we waiting for?
So, your permission, we can start?
No need to permission. Permission is eternally available to you.
Thank you so much, sir. Right. So, a very good afternoon to all. On behalf of the Center for Criminology, Criminal Justice and Victimology, I welcome you all to this 5th session of our event. The topic for the discussion today is empowering victims against secondary victimization. The panelists we have for today are Professor Dr. Heru Susetyo, Dr. Hanif Quereshi, Professor Dr. Beulah Shekhar, and Professor Garima Jain. The moderator for the session is my teacher and senior colleague who I have much to thank for, Mr. Neeraj Tiwari. Mr. Tiwari began his academic career from the Hidayatullah National Law University, Raipur, post which he joined the National Judicial Academy, Bhopal in the year 2012. At the National Judicial Academy, he performed the task of conceptualizing academic programs for judges, conducting research in the areas of criminal justice, taking interactive sessions, and coordinating program for the judges at the Indian judiciary. At present, Mr. Tiwari is serving as an assistant professor at National Law University, Delhi. He is also associated with the UGC EPG Patiala project on law and criminology in the capacity of a program coordinator. He has successfully coordinated 2 papers on criminal justice administration and penology and sentencing. Now, besides organizing various seminars and conferences, he has also presented papers at various seminars and conferences himself. Presently, he's pursuing his doctoral work on the topic of role of magistracy at the pre-trial stage under the Indian criminal justice system from National Law University, Delhi. He has also been associated with the Committee for Reforms in Criminal Laws in the capacity of a senior faculty. Neeraj sir, thank you so much for agreeing to grace us with your presence. Without any further ado, I request you to kindly take over the session.
Thank you, Ankit, and thank you everyone over there from the CCV side. Thank you, Vajpayee sir, for allowing me to be part of this special program on victim. And we are now moved on to the 5th session of this colloquium, and the sessions, as I have also been part of few of them, we have seen a progress from victims movement from access to justice to judicial response, and now finally we have reached to the session on empowering victim against secondary or re-victimization. It is going to be a very, very fascinating session, I must say, because we have one of the functionary right here with us as one of the speakers, because their interaction with the victim is so important when it comes to the victims and the criminal justice system. So without taking much time, let me introduce the eminent speakers of this session. We have with us Professor Dr. Heru Susetyo. Professor Heru is presently as an associate professor at Faculty of Law, University of Indonesia, and he has already completed one PhD, and now he is pursuing his second PhD from Tilburg University, Netherlands, on victimology. Professor Susetyo has also been associated with several international organizations, including the World Society of Victimology and Victims Support Asia. He is also the recipient of various awards, including Republic of Indonesia Honorary Medal by the President of Indonesia 2006, Outstanding Lecturer of FHUI Award 2008, and Dean of FHUI Award 2020. I, on behalf of the organizing team of this colloquium, welcome you, sir, over here to hear you on this very important issue of victims' empowerment towards re-victimization or against secondary victimization. The second speaker of the day is Dr. Hanif Quereshi, who is an IPS officer and presently serving as the IG Police, IRB, and Secretary to the Government of Haryana. He has also been the Senior Superintendent of Police of 8 districts and IGP of 2 police ranges in Haryana, apart from being the Commissioner of Police, Faridabad. As the CEO of Haryana Waqf Board, he also established the Mewat Engineering College, and the passion for it surely comes from his own background because he himself possesses the degree of BTech and MTech. And Dr. Qureshi has a PhD in criminal justice from University of Cincinnati, USA, and apart from that, he's also a TEDx speaker and featured in so many write-ups, editorials in different journals and daily newspapers. The third speaker of the day is Professor Belwa Shekhar, who is presently Chair Professor of Criminology at the Jain Institute of Criminology and Forensic Science, New Delhi. Formerly, Professor Belwa was head and professor of Department of Criminology and Criminal Justice Sciences at the MS University, Tamil Nadu. Professor Belwa has been involved in training the police officers and judicial officers on the subject of victimology from in the past. Her various research papers and articles have found place in different national and international journals, and naming few journals which are published outside involve the journals being printed in UK, Portugal, Switzerland, Indonesia, Taiwan, Canada, naming few. She has also served as a member of the national consultations in various reforms and evaluations of the legislation and the working of the criminal justice systems. She was invited as an individual expert at the 12th UN Congress on Crime Prevention and Criminal Justice in Brazil. She has been recipient of various awards, naming the most important one is she was Fulbright Fellowship 2014-2015. And I welcome you, Professor Belwa, along with other speakers. And lastly, we have the privilege to welcome Professor Garima Jain, who is currently serving as the Assistant Professor, School of Psychology and Counselling, OP Jindal Global University, Sonipat. Prior to joining JGU, she served as Assistant Professor as Shahid Rajguru College of Applied Sciences, Delhi University. Her work is also practice-led, and she works in collaboration with social workers and feminist organizations on spreading awareness on women's rights. She is a member of the World Society of Victimology and has served as an individual expert at the United Nations Commission on Crime Prevention and Criminal Justice. She has conducted workshops in several institutes on gender psychology, rape culture, parenting and gender roles, feminist lawyering techniques, and others. So I take this opportunity to welcome you all in this session on empowering victims against secondary victimization. As the topic is very, very clear, that how victims can be conferred certain rights within the system to prevent any act of re-victimization, either in the hands of the society, family, or in the hands of the functionaries with whom they are dealing in the progress of the case. And it is going to be very, very interesting talk and discussion. Why? Because it requires a two-way response to this re-victimization or to preventing this re-victimization. One from conferring victims' right and services or recognizing victims' right and services within the system. And on the other hand, obligating the functionaries to give due focus or attention to the rights and the services to the victims so that the victims are not allowed to be re-victimized in the process. So with these words, let me tell you, this session is going to be an hour and 30 minutes long. Every speaker will have roughly 15 to 20 minutes, and it's going to be a conversation mode. So we'll have more participation from the side of the speakers, and I'll also intervene as and when it is required. But without wasting much time, I would like to invite Professor Heru Susetyo to initiate the discussion on this very important issue on empowering victims against secondary victimization. Over to you, Professor Heru.
Okay, thank you so much, Professor Neeraj Tiwari, and also good afternoon for everyone, especially my senior, my Professor Counselling, Professor Bajpai, and also Professor Biola Sekar. Glad to see all of you, even though only in the WebEx, but hopefully we will meet in the near future, perhaps in San Sebastian in Spain this year. And also thank you for the invitation for Center for Criminology, Criminal Justice and Victimology at the Rajiv Gandhi National University of Law. I'm very honored to be invited by this program, and I also have spread this program to my colleges in Indonesia, and they love to join it, but because this is actually in coincidence with Ramadan time in Indonesia, so less people would join this program. Okay, can I share my PowerPoint?
Sure.
Yeah, this one. Is it? Can my PowerPoint or yeah? Yes. Yeah. Sorry. How long is my time?
15-20 minutes.
Okay. Maybe I need only 15 minutes. So according to the topic that given to me is and all of presented today is empowering victims from a secondary victimization. Of course, this is a very serious problem because we know quite sure that many victims are actually also experience secondary victimization, not just in the criminal justice system, but also in other places. And many government officials, even the law enforcement officers, actually not really understand the rights of the victims. Therefore, empowering victims before the criminal justice system to prevent them from secondary victimization is actually very important. And in case of Indonesia, let me share the problem in the Indonesian criminal justice system, that victims in this country is not really well represented, still less represented in criminal justice system. Even though the country is quite huge with almost 76 million of the fourth largest in terms of population after China, India, and the US. But still, victims are still less represented in criminal justice system. So, and the offender are still they can like offender of criminal justice system. So the attention from the mass media, from the law enforcement, from the police, from the judges, and even the court, mostly they pay attention to the offender, not the victims. Because of course, victims still got secondary victimization, not just in street crime, but also in the organized crime. And the penal code in Indonesia actually already 105 years old. So it's quite old, because actually we got it from the Dutch or from the Netherlands when this country colonized by Dutch for 3.5 centuries, and before we got independence in 1945. So actually we got the penal code from the Dutch or from the Netherlands, and until now it's not really amended. So most of the articles still the old one. So there is no clear rights, no clear rights of the victim, protection, facilitation, rehabilitation, remedies actually are not really clear in regard to the victims in the penal code. And the law on criminal procedures enacted in 1981 and also does not really cover victims' rights. Only pay attention to the offender, the indicted person, the suspect, not for the victims. However, since after 1998 reform movement, because this country got like a reform or revolution in 1998 after the long president, namely Suharto, he has been in power for 32 years, and then he resigned in 1998. After that, the country turned to be more freedom and more liberty, and a lot of legal institution law are also actually enacted and introduced to the people. And also the grassroots movement since 1990 are quite growing and developing until since 1998. Before 1998, still under, let's say, the tyranny or under the strict dictatorship of the previous president. So the initiative to protect the right of the victim, to fulfill the rights of the victim, actually come from the state, and as well as from the non-state actors, from the grassroots, from the common people, where they choose to introduce the legal approach as well as the non-legal approach. So it can be legal approach or a non-legal approach. There are some legal initiatives to protect, to secure the rights of the victims, including from secondary victimization. Actually, it began in 2004 when the parliament and the government enacted the anti-domestic violence law 2004. At that time, the victims of the domestic violence mostly are women, but not all of the women. They got more protection from the court, from the criminal justice system, and so to prevent the secondary victimization. But the problem is, as we have been aware of, enacting the law alone is not enough. So we produce a law is not enough to prevent secondary victimization. We need to also educate the people, train the people, educate the criminal justice officer, educate the law apparatus, because sometimes the law is good, the law is nice, the law is proper and better, but the attitude, the culture, are insufficient to understand, to respect the rights of the victim. So the problem is not just the law. The law is there, but without proper attitude, proper training, proper respect to the victim's right, then it's nothing. So I would like to also propose we need to also train, educate, and facilitate the cultural change, or even though it's not easy to change the culture, but we believe that day by day we can let's say we can improve, and we can the culture to respect the victim's right. And anti-human trafficking law in 2007, and the real victims law actually was enacted in 2006 and amendment in 2014. The law on victims and witness, sorry, this is wrong. Victims and witness protection law. Special law enacted for the victims and witness was enacted in 2006, and also the amendment in 2014. And it's also mentioned that the law enforcement apparatus or official of the police, the prosecutor, the judges, must also respect, understand, and fulfill the rights of the victims of crime. But again, the law is not enough. Law is not enough when the attitude is still different. The brand new law on terrorism, Anti-Terrorism Law 2018, actually is also introduced a new approach to victims of terrorism. It provides more rights and more protection for the victims of terrorism, right to be heard, right to get compensation, restitution, right to get medical assistance and psychological trauma support, something like that, and also to prevent them from secondary victimization. But again, law is law, but the attitude is different. And before that, we have Human Rights Court Law in 2000, and it's also tried to fulfill the rights of the victim of genocide and victim of crimes against humanity. And currently, the parliament and the government is drafting the proposed law on anti-sexual violence, still under discussion and debate in the parliament. And the law actually mentions about how to prevent the victim from secondary victimization, not just from direct victimization. So here is the case, the example of legal initiative. And there are another non-legal initiative to empower victims. It comes from the NGO or the non-governmental organization or civil society organization. So it's more community-based rather than the state-based initiative. There are some initiatives made by the NGO. They try to train, to educate and to facilitate and to protect the victims of any victims, but mostly are victim of domestic violence, victim of, as well as victim of sexual violence. And the state also introduced the P2TP2A, or like a center for preventing and protecting victims of domestic violence. Actually, this initiative come from the state, and the state instruct that the government must have this center in all regencies, all cities, all provinces. So there are 34 provinces all over Indonesia and around 500 cities and regencies. So the central government instructed that every cities, every provinces must found the P2TP2A, or Center for Preventing and Protecting the Victims of Domestic Violence, and also for women and children. And also introduce, because today we have arrived to the 4.0 digital revolution and 5.0 society. So some NGO introduced the apps or the internet-based through, we can be downloaded from Play Store or App Store or Apple Store, like how to facilitate the victims of sexual violence or crime and other victims. And also another movement is socio-political movement made by the students, by the NGO, by the civil society to extend and to improve the rights of the victims of crimes. And here are some initiatives that I can address. Like Into the Light. Into the Light is the NGO who actually try to facilitate or to accompany people who are depressed. People are in depressed, in stressfulness. So if they want to commit suicide, then this NGO will try to accompany and to be their friends, to listen to these people. And then secondly is in Hope Health, sexual violence victims. This initiative actually based on the campus-based initiative to protect and to prevent people on the students as well as the faculty member from sexual violence inside the university, inside the campus, by providing support and apps and a contact number or hotline to help them. Also to prevent them from secondary victimization from the local government or state official. And then AIDA, or it's a support center for the victim of terrorism, to create the peacefulness of the victim and to provide more rights for the victim of the terrorism. The name is AIDA, and the last one is Pulih Foundation. Pulih in Indonesian language means recover or recovery.
So Professor Heru, if I may interrupt you here, you made a very pertinent remark about the legislation which is prevalent in your country. The 1981 Act does not cover the victims' movement or victims' right at all. There's a complete absence of that.
Yes, that's right.
So how you see what significance this law on victims and victim protection 2006 and 14 play in this very domain? Because mostly the re-victimization can be prevented by coming up with more and more assistance oriented facilities as the fourth limb of UN declaration. So we all would like to know about those initiatives which have been done under these 2006 and 14 victim protection and non-victim. And because the need of victim is also very different, actually. It's like victim of sexual offense, domestic violence, trafficking. They all have different needs. And those needs, so basically the assistance is need driven. So can you please throw some light on that as far as Indonesia is concerned, like how this has been made there? Because the main legislation is completely, you're stating that silent on this very aspect. Please.
Okay, thank you, Professor Neeraj Tiwari. Yes, the law number 13/2006 actually founded a new center, namely National Agency for Victim and Witness Protection, since 2008. And it has the mandate to cover the victims of crime all over the country. But actually, there are some weaknesses as well, because the centers only, it has no branches, no chapters, only in Jakarta as in the headquarters, and also lack of staff, lack of budget. But so for the first time, they only concentrate in some victims of crime, only victim of terrorism, victim of crimes against humanity, victim of domestic violence, victim of corruption and money laundering, and also victim of genocide. So only, I think, 5 to 6 kind of victims. So the problem, and yes, there are not just legal officers. There are some psychologists, medical doctor inside them, and also the police officer. So they try to identify what kind of the needs of the victims. So they need to assess them first, and assess the need of the victim. After that, they will try what kind of the action need to be put to the different victims, because they have different needs, right? And the difficult one is the victim past human rights violation. Like the agency actually handled the victim from 40 years ago, when the killing of the Communism Party supporters. The Communist Party supporters in the 1960s and 40s are still actually facilitated by this agency. And this is quite difficult, because it's already after 50 years after that, and to address the victims' need are quite different. Again, people are still angry with the support of the Communist Party until now. Most people. So actually, it's quite difficult to address the needs of the victim of past human rights violation. That's why this agency is still in actually developing the method, the approach, and improving the budget and the staff to accompany and to fulfill the needs of the victim which come from this kind of crime.
And my second follow-up question is basically on the very culture of inculcating the culture of the knowing the needs of the victim as far as the assistance is concerned, and secondly about educating the law enforcement agencies. So how that has been taken care of under these special laws or under the victims and victim protection legislations or rules which has been framed in your country?
Yeah, it has also the mandate to educate educate the common people, also the victims, to strengthen the victims, to uphold the standard and to educate the victims. But they don't work alone. They work hand in hand with the NGO. There are some NGO actually as a partner of the agency, so they work together to educate or to accompany the victims so they can understand their rights before the criminal justice system.
So yeah, thank you, Professor Heru. We would like to hear you more on the later part of this session. And we would surely welcome your intervention also. Now we are moving from first presentation to the second presentation. And I
Thank you so much.
welcome Dr. Hanif Quereshi, because you represent one of the very important functionary of criminal justice, having the first-hand interaction with the victim of a crime when the victim is subjected to any such criminal act. So we'd like to hear from you, sir, on this very issue. Let us have Professor Hanif Quereshi, Dr. Hanif Quereshi, to share his experience and the some of the realities which the victims has to undergo or face in the entire progress of a criminal case where the victim gets interaction with the police as an agency. Over to you, Dr. Hanif Quereshi.
Thank you, Professor Neeraj. First of all, I would like to congratulate the university, particularly Professor Bajpai, for organizing the conference. Good to see Professor Chockalingam and other senior people and listening to their views. Particularly Professor Heru talked about that the law exists, but the attitudes need to be changed. I would take a very different view on it. I do not think that even the laws are adequate. I think there's a lot to be done as regards the law is concerned, and also a lot to be done as regards the culture is concerned. But first, let me come to you asked me about the police and the interaction with the victims. And Professor Heru also talked about educating the police and educating the victims. Now, education is all good, but what to educate? What to tell the police? What to tell the victims? What is wrong with the system? First, we must know that. If we know what is wrong with the system, what is wrong with the attitudes, what is wrong with the practices and policies which are actually implemented by not only the police, but by all the functionaries of the criminal justice system. The first interaction of the victim usually is with the medical people. What happens in the hospital? Then the police comes, then investigation, then prosecutors. What are the attitudes of the prosecutors? So I think that in our criminal justice system, since it is an adversarial system, the center of attraction is the accused. Most laws, the standing operating procedures issued by state governments and MHA, they are about accused. Very few SOPs or policies or procedures are about the victims. Victims have been forgotten. We are talking about secondary victimization, but even victims are forgotten. So what to talk of secondary victimization? Most of us do not even know what is secondary victimization. I just want to go into a little bit of a history as to why the victims came to be forgotten. Victims were not always forgotten. Institutional restitution has existed back to thousands of years. The Babylonian Code of Hammurabi provided for victims to receive payment for property offenses. Mosaic law had a system where thieves had to pay oxen to the victims from whom they had stolen. The Roman law of 12 tables, that also required repayment schedules for theft of property. The Middle Eastern codes like the Sumerian code of Unnamu and the code of Eshnunna, they also required restitution. But things started turning around the 12th century when King Henry I of England, he drafted the code Leges Henrici. That code redefined offences as crimes not against victims, but against the king or the government. So king was the true victim of crime. So compensation shifted to the crown. And from there, the erosion of the restorative idea began. So other philosophies like deterrence or incapacitation or rehabilitation, they were invoked to justify punishment. So governments around the world, starting with British government, of course, they started taking increasing control of the justice system. And retribution became more important as a sentencing philosophy. And modern state assumed all investigative, prosecutorial, enforcement functions. Crime now, after 12th century, became treating as disruption of the state security. Not so victim fell out of use. There was less discussion about the victims. So, I mean, we can speculate about the causes, why it happened. One was that the fines now will be given to the state, not given to the victims. So, the state wanted funds. So, restitution will come to the funds. It is only in the 20th century that this idea of victims has come back to the center stage again. So, now United Nations is talking about it. So, various state governments, national governments are talking about it. Unfortunately, in India, I mean, if you look at the worldwide, then in India, we are still way behind the policy initiatives that I would say. For instance, look at the definition of victims. Section 2 in the CRPC says that victim is a person who has suffered any loss or injury due to omission for which the accused person has been charged. And the expression of victim includes his guardian or victims. Now, this definition, first of all, it doesn't quantify or reveal what is the loss or the injury. That's not clearly defined. So it is subject to judicial interpretation. Secondly, this injury, this act of omission or of the accused person, that does not consider secondary victimization. So formally in India, we have not defined secondary victimization. But if you look at some other jurisdictions, for instance, in the United States, the Office of Victims of Crime is there. They have defined secondary victims as individuals other than the person directly victimized who has experienced harm as a result of crime. So a family member can be a secondary victim, a close friend of the victim, he or she can be a secondary victim. So in United Nations also, the secondary victimization is when the victim suffers harm at the hands of the criminal justice system, going through the process of trial. So secondary victimization, I think one is that re-victimization, as you have earlier referred to in the discussion, when the trial takes place. But the other is the people who are connected with the victim. They may feel guilt, they may feel shame, they may feel responsible for what has happened to the victim. So firstly, this is a concept that we must explain to all the functionaries of the criminal justice system. Many police officers do not realize that when a victim comes to the police, the way they are questioned, the way they are described, they relive the pain. So that is also victimization. So that has to be done. Now, so one is the law needs to include the definition of secondary victimization in India, because unless law changes, on what basis will you say that this is secondary victimization? So law, I think, has a great role to play in changing culture. There was a time in Delhi when nobody used to wear seat belts while driving. But when the law was enacted and the government said that everybody must wear a law, it became a culture. Now everyone wears this. Everyone wears the seat belt, even though it was important earlier also. Therefore, I think changes law is also important. And the changes law is not only as to the definition of secondary victimization, but what is to be done for secondary victimization. In this regard, there's a country in Europe, Latvia, they have come out with a compendium of good practices, that what steps they have taken to prevent secondary victimization. And they have, it was taken up by the European Secretariat, and they have evolved a 3-part matrix to handle secondary victimization. In first part, they have talked about the policies and the legislation in various countries in the European Union. Then they talk about what are the good and promising practices, various countries which they have undertaken, and then particular examples of what interventions were done to actually implement those practices. So a lot of literature on that is already available in these European countries, but such a literature, unfortunately, is not available in India. So one thing is law, the other thing is the practices, the what is actually done to implement those laws. That is also very important.
So,
And
Dr. Qureshi, if I
yes,
interrupt you here,
yes.
because there are two things actually. Like one, is there any lack of laws to address the issue of re-victimization, or there is an attitudinal lapse on the part of the functionaries due to which the
Yeah,
victims suffer re-victimization, or we
yeah.
lack
So
both actually?
let me answer your question.
Because
Definitely,
you
there is a
see,
lack of
let,
laws.
let me just
Number
have a
one.
follow-up question to you.
Yeah,
Because you see, there are certain protections which are in place in the Code of Criminal Procedure, like
very
non-publishing the name
less.
of the victim, not
That is
disclosing the
peanuts.
identity.
No. That is true. That is what, my dear, I'm trying to tell you that these protections are peanuts. We are way behind in making laws which the Europe and USA have already done. We are way behind it.
Exactly,
Just
exactly.
not publishing the name of the victim is too less. We don't be satisfied with
Yeah,
this.
but
So
that's a
it,
step towards
a
securing the
baby step.
victims
It is a
assistance
baby
and
step.
reducing the chances of re-victimization.
Yeah, no. It is a very baby step, and we need to take a lot more steps. What are those steps? One step is look at the act. Look at the Office of Victims of Crime. So, in the US, the Office of Victim of Crimes have enacted an act, Victims of Crime Act, VOCA. Now, Victim of Crime Act defines victims and what is to be done. Now, in India, we do not have any Victims Act. There is no act on victims in India. We have CRPC amendments, we have judicial announcements, we have certain policies or guidelines issued by the government, but there is no act. So there are a number of acts in the United States. There are a number of acts in European Union which elucidate what is victimization, what is secondary victimization, what are the policies and practice should be done. So there's a vacuum there. That is number one. That has to be addressed. Now, coming to the second part, attitudes. Yes, we have a large amount of work to do in correcting the attitudes of whom? Of the entire society. That includes offenders, it includes victims, it includes police officers, it includes prosecutors, judges. So one study was conducted I'm talking about the attitudes now. One study was conducted in Germany. It was about why secondary victimization occurs. What are the causes of secondary victimization? And they published the studies. What are the potential causes? One of the potential causes is so they did a linear regression and they found that trust in the legal system, that is one thing, that is one cause. Faith in a just world, that is another reason. So, just world, you would be knowing that, but for the purpose of elucidation, I'll say just world means that good thing happens to good people, bad thing happens to bad people. That's a just world. So, if a rape victim is there, people will believe she must have done something wrong. That is why she has been raped, So that is a just world. Now, these are the attitudes or beliefs of the society which need to be changed. In that study, it was revealed
Exactly. So,
that
yeah, initial
more,
remark was this only, that attitude of society needs to be changed along with the attitude of the functionaries. I agree on this point that there is no comprehensive law to address the victim re-victimization as a whole, or even the victim's rights as a whole. But even those which are already in place, they are not honored. And time and again, we see there's a breach from the side of the functionaries where the re-victimization occurs due to failure of the functionaries in adhering to those small steps which have already been taken and are made part of the Code of Criminal Procedure. So I think I
yes,
will come back to you again, Dr.
okay,
Qureshi. Let us have
okay,
other speakers also to have their opinion. And thank you, Dr. Qureshi. I would like to invite now Dr. Dula, and she will also have, I think, a great insight on this issue because she has a vast experience dealing with the subject of victimology for so long. So I invite Professor Dr. Belwa Shekhar to give your or her opinion and remarks on this issue. Over to you, Professor Dr. Belwa.
Thank you very much, Professor Tiwari. And thank you, Dr. Bajpai, for this wonderful platform and a very timely one as well. And thanks to my co-panelists who have put things in perspective and made it easier for us to carry on with this panel discussion. And I have to thank my teacher here, Professor Dr. Chokkalingam, for being here, and he's the reason we are all involved in this victimology and victim assistance. Thank you, Professor Chokkalingam, for leading us in such a great way. So having said this, my presentation, can it come on, please? I'd pass it on to
it's visible now.
Someone to. Yes. So what I thought I would do is I would just touch upon the 5 points that were given for the panel discussion. So the first one would be recognition of victims. Next slide, please. Next slide, please. Yes. So I'd like to touch upon the recognition of victims and victimhood by the state. This is a very important area of discussion, and I'm glad it was put here in the points for discussion in the panel given to us by the organizers. So there is a call to refer to people affected by crime as survivor, but there's also a school of thought that thinks it's time to reclaim the word victim. It's important to recognize that word victim and victimhood, because being a survivor sometimes minimizes the impact of the trauma. So I would say the use of the word victim gives the persons certain legal rights. So you need to recognize this victimhood, and it's crucial to recovery. So we need to use, because after a very long time, we have got the word victim defined in our statute.
Professor Belwa, sorry to interrupt.
In 2008 did it.
Professor Belwa, could you please switch on your camera?
Yes.
To if there is no.
I'm trying to switch it on. Yeah, I tried to switch it on even earlier, but it doesn't seem to come on.
Okay. Then please carry on then. Thank you.
Is it okay now?
No, you are not visible.
No. Okay, because I tried it earlier as well, and I'm on the mobile, so maybe that's a reason. So, yes, coming back to it, this victim to survivor, that's a passage that the victim takes, and with the help of all the victim service providers and the functionaries of the criminal justice system. That's when you evolve into being a survivor. So it's important that we do not drop the word victim and use survivor instead. We need to recognize this victimhood, and I'm glad that the organizers had put this point for discussion here. So we have recently introduced the word victim in the criminal procedure code. So we need to use this word, and it's important that this is in line with the UN declaration, and it also recognizes the victims, the ones who helped the victim in the when the crime was being committed, and the legal heir, and all these people are also included in the word victim. So you need to recognize the word victim and this victimhood as well. And also another point that we need to look at here is all the 4 wings, how we need to gear up to make and to facilitate this access to justice, and to make this criminal justice system a victim-friendly victim justice system as well. So very rightly said, the legislative wing, we still do not have a comprehensive victim legislation in our country, and we are doing it in patches. We have compensation, we have assistance to victims, but we do not have a comprehensive victim legislation per se. And coming to the enforcement, we need to sensitize the frontline professionals, to prevent secondary victimization. And in the judicial wing as well, the victim impact statement has to be included. Amicus curiae would also enhance the role of the victim in the criminal justice system. And another very important thing is when the judges marshal in the scientific evidence. When we did a study on the reasons for acquittal, we found that many of the scientific evidences that were presented by the defense, by the prosecutor, was not marshaled in because of the lack of clarity in the chain of custody and things like that. So that has to be strengthened as well. And coming to the correctional wing of the criminal justice system, the information given to the victims about the parole, the bail, would really go a long way in safeguarding the victims and reducing the victimization caused by the offenders themselves. So this is one point I wanted to make. And next slide, please. Can we go to the next slide, please?
Yes, it's visible now.
Okay. Yes. Yes. So I was looking at the duties of the police officers. Duties of the police officers towards the victims. And this is a large area that we need to cover to prevent victimization, the secondary victimization per se. So when they arrive at the police station, the reception, the treatment meted out to them, if they are treated with respect and dignity, and whether the police station is welcoming and victim friendly. So we have the concept of all women police stations now in our country, which has gone a long way in providing victim friendly services there, and actually attracting the victim to come into the into the police station to register the first information report. And another area where the police also can prevent secondary victimization is by giving information about the compensation available to the victim, about the facilities, the available services to the victim, like the services of the lawyer for the pre-legal aid, the psychologist for counseling, the doctor for the medical tests that follow the of a case. And basically even a social worker who would accompany the victim to the various institutions where the victim would have to go to pursue a case. So this kind of information, this also falls largely on the police to prevent. And to address this, we had in Tamil Nadu introduced the Victim Assistance Fund that was given to some victims of crime. And this was done through the police. So this also encouraged the victims to be more connected with the police, and this kind of enhanced the relationship they had with police as well. And I'm glad to say that the Indian Society of Victimology, under the leadership of Professor Chockalingam, took the initiative to introduce this Victim Assistance Fund, which is now available in all the other states as well. So that also reduces the secondary victimization. Then the ambience in the police stations, the demeanor in the courts, and the demeanor of the police, of the lawyers also go a long way in addressing the secondary victimization suffered by the victims in the police stations. And in some cases, it is not necessary that the police are directly aggressive towards the victim, but even if the victim sees this aggressive behavior to others in the police stations, that also will intimidate the victim and prevent him from reporting the crime in a manner that would help the prosecution as well prove the case. So this also relates to the secondary victimization and providing the assistance. Like in these all women police stations I was talking about, we have a list of doctors, lawyers, psychologists, counselors, and social workers. So the victim, when she enters the police station, she can ask for the assistance of one of these people to help her through this process of going through the criminal justice system and going through till the trial of the case. So this would reduce a lot of secondary victimization if this happens. Then moving on to the third point, prosecutors' role in securing victim justice. Here again, there are a lot of challenges and there is a problem in the process because as we see, like I was talking about the case, the study that we did with the reasons for acquittals. So we see that many of the cases were acquitted because there was lack of presentation of the scientific evidence. And this we see in India that we need to much before include forensic science, forensic medicine, criminology, and victimology in the law curriculum in the country. This would upgrade the skill of the lawyers who present the scientific evidence. Now they're largely dependent on proxy professionals, but they need to have knowledge so that they would be able to present the evidence in a manner that it would be accepted. And the judges as well, they are the gatekeepers and of the scientific evidence, and they're the ones who marshal these evidences in a court of law. So then it's important that they have some knowledge about forensic science. And now National Forensic Science University is on the job getting the lawyers to have extra courses on this forensic science that would help and would reduce the secondary victimization of these victims, because collection of the data, collection of the evidence, all this causes secondary victimization, and this can be reduced if they have some knowledge in the area. Similarly, when the police are investigating the crime, it's important right now, only when the CBI is involved do we have a forensic scientist present with the police officer. But it's important that every investigation is done in the presence of a forensic scientist and a criminologist, and this would
Professor
enhance
Bilwa,
the performance of the. Yes.
If I may interrupt here, of course, there are certain very important issues you're raising in this presentation, and what is your take on giving the prosecutor the role of a bridge between the victim and the court proceeding, because the victim's interaction, once the case is out of the hand of the police, goes to the court. I think the interaction with victim and the prosecutor.
I'm just coming to it.
Yes.
Yeah, I'm just coming to it. Okay. It's important the three of them work together. The prosecutor, the police officer, and the victim. They need to have a coordination. And I would say that we need to make it mandatory that they have a minimum of at least 5 meetings before filing the charge sheet. And this would strengthen the case, because now you see that each of them work in isolation and they need to sit together and put their heads together before presenting the case. And this would also help in recording the victim statement and taking into account what the victim has to say and presented to the court in a way that would lead to a conviction and would be taken into account by the judge as well. And another section that we have recently after 2009 added into our statute books is section 372 and 377 of the CRPC, which talks about invoking these sections to challenge the acquittal or to challenge the lesser sentencing for a lesser offense after the case is heard. So this is a very important evidence, and right now we're, important section, and right now we're in the process of researching how often is this section used, though it is there for a victim.
Yes.
When a victim is not
what is
given
your
justice,
opinion?
how many of the victims use it? How many times?
Professor Bilwa, what is your opinion on certain, sometimes
how many
what
times
happens? Yes, if I complete my question, sometimes even making the process mandatory for the victim also results in re-victimization. Victim may not be comfortable in coming to the courts or even being the part of the proceedings. So how do you see that in your discussion?
No, that's important, that the victim's presence is there, and that depends on how the victim is treated in the court of law and in the police station. After all, the victim is working with them to get justice. You're trying to increase the access to justice by using the services of the victim. So if the treatment, if there was a procedure set in place, and then this would not be a harassment for the victim, and that would not cause secondary victimization per se. And another thing I would like to stress upon is the next slide, please. Though we do not have comprehensive victim legislation in our country, but it is there in the Constitution, and it is built into the Constitution. The 154th Law Commission report says that the right to compensation has the rooting in the Constitution, and the principle of victimology has foundations in the constitutional jurisprudence. So the magic word, I would say, is interpretation, how we interpret these things. Then the provision on fundamental rights, directive principles of state policy, all of these talk about a new social order in which victim justice also could be included. And say Article 41 mandates that the state shall make effective provisions for securing the right to public assistance. So in this case, you can talk about it as assistance to victims. So we can interpret our Constitution itself in a way to make
Yes,
it
yes. So I think
victim friendly,
what is
and
more
also
needed now, Mr. Belwa,
interest litigation.
yes, what is more needed now is to
Yes.
take the victim and link the constitutional provisions with the victim, just like we have certain constitutional provisions directly touching upon the rights of the accused. So this is high time that constitutional provisions should be interpreted to confer the rights on the victims. And sorry, but I request you to pause here with your presentation, because we would like to hear the last speaker of the session. And then, of course, the floor will be open for more comprehensive discussion on all these issues, which we are going to have in the later part of this session. So thank you, Professor Virwa, for this presentation. And now I would like to request Professor Garima Jain to share her views and experience with the prevention of re-victimization or secondary victimization, and how she perceives this as a problem or as an issue in the criminal justice system. Over to you, Professor Garima.
Thank you so much, Professor Neeraj. Am I audible?
Yeah, you are audible. Yeah, please continue.
Thank you so much, Professor Neeraj, Professor Heru, Professor Bila Shekhar, Dr. Qureshi, Professor Chokalingam, Professor G.S. Bajpai, and all the respected delegates. Thank you so much for having me today. It is a very respected panel, and I feel privileged to be a part of it. My topic today is going to be about rape myths, victim narratives, and criminal justice system, which is inspired from my PhD work, which I am doing under the supervision of Professor Mark Lowenhutsen in Tilburg University of Netherlands. The topic that I'm going to talk about is very much in tandem with what Dr. Qureshi and Professor Michael have also stated in the chat box about the attitudes of the law enforcement officials. So in any society, certain events occur that prompt the citizen to stop and contemplate. And one such event happened on December 16, 2012 of Nirbhaya rape case, where a 22-year-old physiotherapist was brutally gang raped by 6 males in a private bus, which included the bus driver, 4 adult passengers, and a 17-year-old adolescent male. In 2013, the Justice Verma Committee was tasked on advising the Indian government on the rape law reforms. And based on the recommendation of the committee, Criminal Law Amendment Act of 2013 was enacted. The Act amended the definition of rape from non-consensual peno-vaginal penetration to a range of penetrative and non-penetrative sexual assault without consent. The amended legislation included establishing one-stop centers, women helplines, fast-track courts. The final legislation rejected the Verma's committee's recommendation against capital punishment and retained marital rape impunity. Instead of incentivizing guilty pleas, Indian legislature adopts carceral approach of dealing with sexual violence, marred by amendments from the Mathura rape case to the Nirbhaya rape case. Further to those amendments happened in Criminal Law Amendment Act of 2018, and the POCSO Act of 2019, amended in 2019 due to Kathua or Unnao incident that happened in our country, which also adopted a heavily punitive punitive approach to sexual violence in India. The Criminal Law Amendment Act and POCSO increases the mandatory punishment for rape to 10 years and introduced death penalty for rape below 12 years of age. Professor Mark Gruenhuisen and Michael O'Connor have written a paper on arguments against the death penalty as seen from a victimological perspective, where they quoted, "What is certain is that if we want to truly respect each victims, we cannot cite victims as justification for retaining the death penalty, at the very least without the detail or clarification. Thus, we include that one cannot assert that death penalty serves the victims." I just wanted to highlight some of these statistics despite of knee-jerk reforms that happened in India with respect to sexual violence. The National Crime Records Bureau states that in our country, a woman is raped after every 13 minutes. There are sexual violence in India. It is characterized by a lower reporting rate, high attrition rate, and lower conviction rates. Because our country don't have a sexual victimization survey, so therefore I'm quoting the statistics by National Family Health Survey of 2015 to 16, which estimated that over 98.7% of the total rape cases go unreported in our country. The conviction rates are static at 27.2%, and over 2.4 lakhs of rape and POCSO cases are pending. Anthony Pemberton published an article in 2019 on stories as property, narrative ownership as a key concept in victim experiences with criminal justice. And I would also like to quote one of the papers by Dr. Hanif Quereshi in 2021 on rape myth acceptance among college students in India. And they both have highlighted that despite the stricter law and heavy carceral measures taken up by various countries in dealing with sexual violence, there is little to no evidence of any improvement, largely because of the persistence of rape culture. Mrinal Satish also, in his landmark work on discretion, discrimination, and rule of law, where he has analyzed over 800 judgments of the Supreme Court and High Court between 1984 and 2009, he said that the rape education in India has always been impacted by preconceived notions, myths, and stereotypes about the offender, as well as by the victims of the rape. Pratiksha Bakshi, in her book about the public secrets of law, which is the name of the paper, the chapter is Justice as Secret, has highlighted that rape, despite being a non-compoundable offense, is largely resulting in out-of-the-court settlements and compromise. So I would like to highlight that it is very important that we acknowledge the influx and existence of ingrained stereotype and prejudicial beliefs about the rape survivors. And in 1980, Martha Bird, she published her groundbreaking work on rape myths. She defined rape myths as prejudicial, stereotyped, or false belief about rape, rape victims, and rapists. Bird identified examples of these myths, including women ask for it, rapists are sex-starved, insane, or both. And others are, it wasn't really rape. He didn't mean to. She wanted it. She lied. Rape is a trivial event. Rape is a deviant event. Because of the paucity of time, I would like to talk about two myths today. One is women lie about rape, and second is rapist as a monster syndrome. A part of my work where I conducted an ethnographic research on the rape survivors. One of the survivors' mother, whose husband assaulted his own 15-year-old daughter, said that no one believed me that a biological father can do such a sin. I registered with the police, but the justice system was costly. I took the case back because survival seems to be impossible when my husband is inside the bar. In another case, which is registered under the POCSO, where the woman was later on married to the potential accused, and later on, the accused was then imprisoned for 10 years of jail, despite of the fact that they both got married and the survivor no longer wanted the accused to be imprisoned because they both are now together as husband and wife. So these two incidences actually raises a very crucial question on what does justice actually means to the victims, and how do justice is being viewed by the formal criminal justice system of our country.
So, Professor Garima, if I just ask you a very important question here, because you see, among all the amendments which are aimed in recognizing or restoring victims' right in our law, sexual violence victims are the one who are at the center of all these amendments. And much have been done through laws to protect and safeguard their dignity, their reputation, their rights, and also some of them are directly linked to the victim assistance or services. Still, what you began with in your talk about the attitude, and what we can see in the chat box also, what Professor Sarah and Michael are writing about the attitudinal change. So how do you see that? Because in most of these cases where rape myths are present in the minds of almost all the functionaries, because we see some cases have come in the past from Bombay High Court also, which are too I must say conservative approach has been shown by the courts also in dealing with such cases. So how these attitudinal shift can be reached or can be achieved under the present amended laws, or you propose that certain more stringent laws, as mentioned in the chat box by Michael, is required for such attitudinal shift in the minds of the functionaries?
Thank you so much, Professor Tiwari, for such a good question. Well, I was going to cater to this question towards the end, but still I would like to highlight that when it comes to, as a psychologist, when I teach attitudes to my students, so in one of the classes, I asked them, what does it come to your mind when you hear the term victim and when you hear the term accused? And I was about to also present that as a part of my presentation today. And in one of the similar research was conducted by One Future Collective in 2019, where they asked some of the community social workers, in which I was also a part of that particular focus group discussion. And they asked, what does it come to your mind when you hear the term rapist? And they said that somebody who is a male, somebody who is aggressive, somebody who is a psychopath, somebody who is a criminal. So basically, and whenever, similarly, when I ask my students about what does it come to your mind when you hear the term a victim, and they said somebody who is a female, somebody who is vulnerable, somebody who requires some help, somebody who has. So these are some of the common characteristics that the students echoed in a lot of my classes whenever I ask this question and pose this question. I think the majorly, if we just go and talk about the law enforcement officials, I think before that they are coming directly from the society. And as a society, there is a very inherent patriarchal attitude and sexist attitude that exists.
Yes.
So, and it is not just the law enforcement officials. I think it is everywhere, and that's how the interventions should start from the schools, from the boys' locker banter, which is so like there has been so much so much that has been covered about it, and how teenagers and adolescents are also involved in sexist remarks or misogynist remarks. So I think then only it will get percolated towards.
Yes. I think it needs to start at the very early stage or the level to change this attitude, and it doesn't come when the person is possessing any position, but of course it shall start from the very family or the society where the person is residing or staying. So I need to actually cut short your presentation, and thanks each and every speaker for this session 5 today, and I thank Professor Heru, Professor Dr. Hanif Quereshi, Professor Bilwa, and Professor Garima Jain. And I would like to have questions from the participants who must be eagerly waiting to have their opinion also be shared with the eminent speakers. And we have got the first question from none other than Professor Vajpayee. So over to you, sir.
Thank you, Neeraj. It's more of a observation which any panelist can respond to me. I believe that secondary victimization, which has been discussed in different contexts with, of course, in the last presentation, Dr. Garima brought it into the context of sexual offenses. So this probably brings us to conclude that secondary victimization is becoming quite thematic and very, very unique in terms of its nature, extent, and consequences regarding the nature of offenses in which the victimization happens. So probably the victimization in sexual offenses is not comparable to non-sexual offenses victimization. So I think one very important takeaway is that I find that there are two types of secondary victimization. They can correct me as I am gathering. That one is essentially the collateral and consequential. So if, by virtue of a victim, he has to deal with the various agencies. So there is a consequence always. And second is deliberate and by design. So agencies are indulging at Mr. Qureshi, Dr. Qureshi was saying the role of police. So there is a deliberate indulgence by a certain person, and there are consequential also. So do we have a preparedness? Because we generally treat secondary victimization as a collateral issue that has to be dealt with in a very sidelined manner. Now, mainstreaming secondary victimization, don't you think the speaker would require the role of specification regarding the role of state actors and role of non-state actors, how they need to respond? And probably it generally remains unaddressed because the network of services is not there. So police is not an agency, probably something which they can do something to heal the consequences of secondary victimization. They don't have that capacity. So who is entrusted with this capacity and the caliber to ease the consequences, secondary victimization consequences? So some of these questions need to be answered, because I feel that this should become a very centralized subject. We are dealing that victimization happens, there are consequences, there are secondary victimization. But secondary victimization is more traumatic at times than the primary victimization. But officially speaking, there is no arrangement to address. When the case is on, there is no agency except NGOs and all who can probably actively intervene. Of course, in law now some provision is there that you will not disclose the name, you will not confront. But still there are some, like Dr. Garima was talking, there are emotional consequences. There are some person is evaluating, remarking. There is absolutely no space at the moment. So how this can be responded is a question any participant, any panelist can address this.
So who would like to respond to Professor Vajpayee? Professor Bilwa, yes.
Thank you, Dr. Bajpai, for that very pertinent question and drawing attention to that. Yes, we have initiatives. The Supreme Court has been proactive. They ordered a witness protection scheme, which we have to provide vulnerable victims deposition centers. Each High Court is supposed to have 2 vulnerable witnesses deposition centers in their jurisdiction. But unfortunately, only in 2019 did Gujarat open one. They were the first to open, and we are still yet to see all the districts having this, because this really goes a long way in preventing secondary victimization. Those vulnerable witness deposition centers. And in the police, we have the mobile police units that go to and register FIRs, which reduces secondary victimization again. And there are kiosks for reporting. In Bangalore, we have, so that again prevents secondary victimization, online reporting and things like that. So we have, the government has taken initiatives. The Supreme Court has given a lot of judgments for establishment of these centers and victim protection. But unfortunately, it has not taken off like we victimologists would have liked to see it. And the in-camera trials, these things are all there, the initiation of various subsections to 357, with the DLSA coming in to award the compensation, to assess the damage done. So these were things that we did not have prior to the Nirbhaya case. So in a way, it has opened a lot of opportunities for victims and for the reduction of secondary victimization. But I think for the government to act, citizens should be active. We need to be at it to beat it. So we need to keep putting pressure to see that these orders have taken shape. Thank you. Thank you very much.
Thank you, Professor Bewa.
Can I also add to Professor Vajpayee's
Yes, Professor Garima, yes.
So I just wanted to add, and I think I will also quote, sir, your own, observation in one of the talks which I attended, and which was that our existing criminal justice system is basically that understands justice from a binary perspective, which is conviction and no conviction. Otherwise, if we just look at the number of cases, especially if I talk about the sexual violence, then it's like a huge number which is not even getting reported. And one of the reasons could be secondary victimization, where victims, they are very scared of going to the police station at the very first place and reporting the crime because of that sense of trust. And I think Professor Hanif Quereshi just highlighted about the just world hypothesis and about the trust that resides in the police force. So because they are the first point of contact, a lot of times survivors, they don't feel safe. So I feel that it is important that we encourage more and more restorative processes and transformative justice processes also consider that as a part of our existing justice system in tandem with our justice system, not like a parallel justice system is not something, and that's where I would like to quote you. And probably we also need something like National Victim Authority of India, which is again something which you only what in one of the talks highlighted. And I think these are the two different things that can be done in order to.
Thank you, Professor Garima. And now we have Professor Sara with a question or observation.
Mine
yes,
isn't really
Sara,
a question. It's more of a response to the current discussion. And I'd just like to share two examples from my work as the administrator of the witness service at Cardiff Magistrate Court in Wales in the UK. So ways in which you could be able to avoid secondary victimization. One of them, of course, is raising general awareness in public, because coming up with a law, as we've said, is not sufficient on its own, but other supportive mechanisms to operationalize it, meaning to make the law serve its function. One of them is just constant awareness raising. When you have a case like the one the previous speakers just talked about, in the newspapers, raise awareness, on social media, which is free of charge, raise awareness. Who is a victim? Everyone can be a victim. How do you help? But now back to the agencies, the police, the prosecution, the medics. It's very important to have actual sessions in which you raise the awareness among them of how their role could actually make the situation of the victim better or worse. Because as Inspector General Qureshi said, it is important, attitude change doesn't happen overnight simply because you passed a law. So what in the UK they do is the police in their normal annual trainings, they include, if they've changed the law, then they include a session on who is a victim. What has happened to this victim? Why are they hesitant? Why are they crying? When you ask them a question, they're crying. So they understand what trauma looks like and sounds like. That is among the professionals. Secondly, you have a witness service or a victim service. And I think Professor Beulah has mentioned that creation of vulnerable witness has deposition. I don't know what that means practically, but the victim support and witness support, identifying areas where you need to specifically target. Police has been mentioned, their work is not easy, but it has been mentioned. Prosecution is easy. But in Cardiff, in the UK, we actually have the witness service and victim support as units within the criminal justice system. The government funds that. That shows that the government is committed to this. They have bought in. You can also raise funds, but it is an integral part of the system. So when the victim comes to court, they go to a separate room. You have special measures for those who can't communicate. I can tell you more about this, or I can circulate a document, but there needs to be, for any law created, you need the supporting mechanism, or don't operationalize it. The support mechanism, training for professionals as well as the witness service, and then make it ongoing training because it's a new thing. I think maybe Michael O'Connell can comment on that because he's been a victim commissioner. It's been mentioned that there is no office of the victims. Maybe Michael can talk a bit about that as victim commissioner for Australia from his experience, both as a police officer and victim commissioner.
Yeah, would like to hear you, Michael, on this.
Thank you. I actually didn't intend to address that question. What I intended to do initially is address the query around secondary victimisation, which I define as the negative experiences or further traumatisation of a victim as a result of the way that they are treated within the criminal justice process and or separate to how they are treated within the victim support and assistance area. And much of the literature and much of the discussion at academic meetings is around the criminal justice system. But when we look at the needs that victims have and go back, as Professor Chocolingam did and several other speakers have done since the beginning of this gathering, mentioned the UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, is one of the fundamental components or sections of that declaration is that a victim has a right to access the mechanisms of justice and the mechanisms of treatment or assistance as defined elsewhere in it. And the sources of secondary victimisation can be in either of those spheres. If one imagines the old school Venn diagram with two circles alongside one another, in the case of a victim experience in the criminal justice system, they are interlocked. And while there are clearly within those domains areas that are unique to the criminal justice system and areas that are unique to victim assistance, victim support, there are also overlaps. And so we need to be more wholesome in our discussions. There are many people who profess to be victim advocates who use their own bias, their own skewed views of the criminal justice system to actually cause victims to have even more negative experiences in the criminal justice system, and we tend to overlook that. Now, very quickly, in terms of my role as the commissioner, whether you have a commissioner or an ombudsperson or someone such as the secretary in charge of an inspectorate, I'm a strong advocate for there being a central authority where victims can go, often as a place of last resort, for the purpose of their grievances, and then that authority having the power to inquire. Now, whether that's actually the power to inquire on individual grievances, as was the case when I served as commissioner, or some of my peers interstate in New South Wales, Victoria are two prime areas, their commissioners had the power to inquire into systemic issues. In other words, having received a series of grievances, they could look at the systems and what needed to be changed. In my humble view, whichever model is adopted, what I have observed is that having a central, strong voice to help drive change within organisations, not necessarily to drive, we want more and more stronger laws and more punishments for people who violate them, but to help drive the change, to bring about and lead the change management. What people like Peter Drucker in management theory call charismatic leaders who can champion a cause. I think that's what is needed. And I've been to India several times now, and I'm of the humble view that that's what's missing in the equation. There are lots and lots of scholars telling politicians what needs to be done, but there's no one in that political sphere running and pushing and shoving and ensuring that victims' voices remain at the forefront of public policy. And that would be my lesson from our experience here in Australia. Thank you for the opportunity to comment.
Thank you, Micah. And we are running out of time. It was really a very interactive session and very intriguing and engaging session, I must say. And to sum up the entire discussion which we had through the learned speakers and also through the intervention of the participants from various parts of the globe. So we all accept and believe one thing, that there are several steps have already been taken actually on the legal side, that laws are in place, but those laws are not effective due to the attitudinal requirement which are not ingrained and not provided to the various functionaries. And how that shift can take place, that is something which is a major point of consideration. Secondly, what we have also witnessed, that a more centralized mechanism can be introduced by which we can establish a witness service unit or victim support unit, giving them a very, very open and a clear role in the entire criminal justice administration, so that they also have a belief and trust that they are not simply being treated as a prosecutor, witness, or a victim separately, who are at the margin. They need to be brought at the center. And also towards the end, we need to see that different victims have different types of needs. So the need-based change should always address the types of victims the system is dealing with. I think that also very much required to be done. And I thank each and everyone for joining this session on empowering victims against re-victimization or secondary victimization. I thank all the speakers and those contributed by participating in the discussion. And I thank Professor Bajpai and to the team at CCV for giving this opportunity for me also to be part of this so valuable session on victim. Over to you, the team at CCV. Thank you.
Okay, thank you so much, sir. So on behalf of the Center for Criminology, Criminal Justice and Victimology, I would like to thank and extend my thanks to Professor Heru, Dr. Hanif Quereshi, Professor Dr. Beulah Shekhar, and Professor Garima. I would also like to extend a very special thanks to Professor Chokalingam, Professor Michael Connell, and Professor Sarah for your very wonderful comments as well. More importantly, I would like to thank all resource persons for sharing your experiences today with us, as well as your knowledge. With your request, I seek to close the session.
Pardon?
So, with your permission, I would like to request. I would like to close this session.
Yes. Sure. Thank you. Thank you, everyone.
Thank you.